In a blistering Supreme Court clash, Justice Amy Coney Barrett unleashes sharp critiques on Pam Bondi's arguments, aiming to unravel her. But Bondi's razor-sharp responses hint at a stunning upset brewing in the courtroom. The air in the Supreme Court chamber was thick with anticipation as the justices settled into their seats. The case before them, a contentious federalism dispute over state powers versus federal overreach, had drawn national attention. At its heart was a question of constitutional balance. Could states carve out greater autonomy in regulating their own affairs, or would federal authority prevail? Representing the state of Florida was Pam Bondi, the former Attorney General known for her prosecutorial tenacity, but untested in this arena of constitutional heavyweights. Across the bench, Justice Amy Coney Barrett, the court's newest and fiercely intellectual member, leaned forward, her eyes fixed on Bondi with a glint of skepticism. Bondi stepped to the podium, her posture steady but her face betraying a flicker of nerves. She began her argument, laying out a framework that emphasized the 10th Amendment's reservation of powers to the states. Her voice was clear, her points methodical. The federal government's attempt to impose uniform regulations on state healthcare systems, she argued, violated the principles of federalism enshrined in the Constitution. She cited Madison and Hamilton, weaving their Federalist writings into a modern defense of state sovereignty. The room listened, but the justices' faces remained unreadable. Barrett was the first to interrupt. Her question came like a dart, precise and cutting. "Counsel, your reliance on the 10th Amendment is broad, but you've sidestepped the Commerce Clause. How do you reconcile your position with Gibbons versus Ogden, which clearly expands federal power over interstate activities?" The question was a challenge, designed to expose any shallow reasoning. Barrett's tone carried a hint of condescension, as if she expected Bondi to falter under the weight of the 1824 precedent. The gallery shifted uncomfortably. Bondi paused, but only for a heartbeat. Justice Barrett, Gibbons versus Ogden addressed navigation, a clear interstate activity. Healthcare regulation, as Florida implements it, is inherently local, touching intrastate concerns like hospital licensing and patient care standards. The Commerce Clause doesn't stretch that far. Her response was calm, her logic tight. A murmur rippled through the room. Barrett's eyebrow arched, but she pressed harder. "Local or not, counsel, the federal government argues that healthcare markets are interconnected. Are you suggesting that Florida's regulations don't impact national markets? That's a bold claim." Barrett's voice sharpened, her words laced with doubt. The other justices leaned in, sensing a confrontation. Bondi's argument was on trial, and Barrett seemed determined to dismantle it. Bondi didn't flinch. "With respect, Justice Barrett, interconnectedness doesn't grant the federal government a blank check. The court's own precedent in Lopez v. United States limits federal overreach when activities are non-economic. Florida's regulations govern local practice, not national trade." She paused, locking eyes with Barrett. "To assume otherwise risks eroding the state's constitutional role." The chamber grew quieter. Barrett scribbled a note, her face unreadable. Chief Justice Roberts glanced at his colleague, sensing the tension. Bondi's response had been more than adequate. It was incisive, but Barrett wasn't done. "Counsel, you're leaning heavily on Lopez, a narrow decision. What's to stop the court from seeing this as a logical extension of Wickard versus Filburn, where even local activity was deemed to affect commerce?" The question was a trap, invoking a 1942 case that had stretched federal power to its limits. Bondi's next words would either solidify her credibility or leave her argument in tatters. She took a breath, her mind racing through decades of precedent. The justices waited, and the courtroom held its breath as Bondi prepared to counter. A challenge that could define the case and her legacy. Pam Bondi stood at the podium, the weight of Justice Barrett's question hanging in the air like a storm cloud. Wickard vs. Filburn was a cornerstone of federal power, a case that had justified Congress's reach into a farmer's wheat field. Barrett's invocation of it was no accident. It was a gauntlet thrown down, daring Bondi to unravel its logic, or crumble. The justice's eyes were locked on her, and the gallery's silence was deafening. Bondi's response would either cement her as a formidable advocate or expose her as out of her depth. "Justice Barrett," Bondi began, her voice steady but charged with conviction. Wickard involved a farmer's output directly affecting a national market during wartime. Florida's healthcare regulations, by contrast, govern non-economic activities, licensing standards, patient care protocols that lack the aggregate market impact of wheat production. To equate the two stretches Wickard beyond its moorings. She paused, letting the distinction sink in. The court in United States v. Morrison reaffirmed that non-economic activities fall outside the Commerce Clause's reach. Florida's framework respects that boundary. Barrett's pen paused, mid-note. Her expression was inscrutable, but the faintest tightening of her jaw betrayed surprise. Bondi had not only sidestepped the trap, but turned it back on the precedent itself. The other justices exchanged glances, and Justice Gorsuch leaned forward, his interest piqued. But Barrett was unrelenting. "Counsel, you're carving out a narrow exception. What's to prevent every state from claiming non-economic exemptions, fracturing federal authority? Your logic risks chaos." The question was a jab, probing for cracks in Bondi's reasoning. The gallery stirred, sensing the escalating duel. Bondi's mind raced. She knew Barrett was testing her grasp of federalism's broader implications. "Respectfully, Justice Barrett, the Constitution anticipates diversity among states. The 10th Amendment exists to prevent federal overreach, not to enforce uniformity. Florida's regulations don't destabilize national markets. They reflect local priorities, as Morrison and Prince v. United States uphold." Her tone was firm, her citations razor-sharp. A ripple of murmurs spread through the chamber. Justice Kagan, usually reserved, scribbled furiously, while Chief Justice Roberts tilted his head, intrigued. Barrett, however, doubled down. "You're relying on cases that limit federal power, counsel, but what about the necessary and proper clause? Doesn't it give Congress latitude to ensure its healthcare regulations are effective nationwide?" The question was a curveball, invoking a clause that had justified sweeping federal authority in cases like McCulloch v. Maryland. Bondi's pulse quickened. Barrett was relentless, each question more pointed than the last, as if determined to expose a flaw. But Bondi had prepared for this. "The necessary and proper clause, Justice Barrett, isn't a blank check. McCulloch requires that federal actions be tethered to enumerated powers. Here, Congress's healthcare mandate exceeds its Commerce Clause authority, as Lopez and Morrison clarify. Florida's approach doesn't obstruct federal goals. It asserts its constitutional prerogative." The room felt electric. Bondi's responses were not just holding ground, they were reshaping the debate. Justice Thomas, typically silent, raised an eyebrow, a rare sign of engagement. Barrett, undeterred, leaned forward. "Counsel, you're arguing for a federalism that limits Congress's ability to address national crises. How do you answer critics who say your framework undermines collective action?" The question was less a query than a challenge, laced with skepticism about Bondi's entire thesis. Bondi met Barrett's gaze, unflinching. The stakes were clear. One misstep could unravel her argument and embolden Barrett's critique. As she opened her mouth to respond, the courtroom seemed to lean in, hanging on the edge of a confrontation that was no longer just about the case. It was about who would command the constitutional high ground. The Supreme Court chamber was a crucible, and Pam Bondi stood at its center, her eyes locked with Justice Amy Coney Barrett's. Barrett's latest question, accusing Bondi's federalism of undermining national unity, hung like a blade, daring her to falter. The justices, the gallery, even the clerks seemed to hold their breath, sensing the clash had transcended the case. This was a battle of intellects, and Bondi's next words would either fortify her position or hand Barrett the upper hand. "Justice Barrett," Bondi said, her voice calm but edged with steel. "Federalism doesn't weaken collective action. It strengthens it by respecting the Constitution's design. The framers crafted a system where states serve as laboratories of democracy, as Justice Brandeis noted in New State Ice versus Liebman. Florida's healthcare regulations don't defy national goals. They innovate within constitutional bounds, balancing local needs with federal limits." Her words were measured, her logic unyielding. Barrett's expression flickered, a hint of respect battling her skepticism. She jotted a note, but her counter was swift. "Counsel, your laboratory's argument is compelling in theory, but in practice, doesn't it create a patchwork of regulations that burdens interstate commerce? How is that not a direct violation of the Dormant Commerce Clause?" The question was surgical, invoking a doctrine that curbs state laws impeding national markets. Barrett's tone suggested she was closing in, ready to expose a fatal flaw. The gallery shifted, the tension palpable. Bondi's mind raced. She knew the Dormant Commerce Clause was a minefield, but she was ready. "Justice Barrett, the Dormant Commerce Clause applies when state laws discriminate against or unduly burden interstate commerce. Florida's regulations are non-discriminatory, applying uniformly to in-state and out-of-state providers. Pike v. Bruce Church sets the standard. Burdens must be excessive relative to local benefits. Florida's rules prioritize patient safety, a legitimate state interest that outweighs speculative federal concerns." Her response was a masterclass in precision, weaving precedent into a shield against Barrett's assault. Chief Justice Roberts tilted his head, visibly intrigued, while Justice Sotomayor scribbled notes. Barrett, however, pressed harder. "You're confident in Pike's balancing test, counsel, but what about the practical reality? Your framework incentivizes states to push boundaries, inviting litigation. Isn't that a recipe for judicial overreach?" The question was a jab, implying Bondi's approach would clog the courts and destabilize federalism itself. Bondi's jaw tightened, but her composure held. "With respect, Justice Barrett, litigation is the Constitution's safety valve. The judiciary exists to resolve these disputes, as Marbury v. Madison established. Florida's framework invites scrutiny, not chaos, ensuring states remain accountable without surrendering their sovereignty." Her voice carried a quiet intensity, each word a rebuttal to Barrett's skepticism. The chamber buzzed softly, the gallery absorbing the exchange. Justice Kavanaugh, usually reserved, leaned forward, his pen poised. Barrett's eyes narrowed, undeterred. "Counsel, you speak of accountability, but your argument hinges on a narrow reading of federal power. What's to stop states from exploiting your framework to evade federal oversight entirely? That's not federalism. It's fragmentation." The question was a grenade, challenging the very foundation of Bondi's thesis. Bondi felt the weight of every gaze in the room. Barrett's relentless probing was forcing her to defend not just Florida's position, but the soul of federalism itself. A single misstep could unravel her credibility, emboldening Barrett's critique and swaying the justices against her. As she drew a breath, the courtroom seemed to pulse with anticipation, waiting for the response that could shift the tide of this intellectual duel. Pam Bondi stood resolute, the Supreme Court's marble columns framing a moment that felt like a crucible. Justice Amy Coney Barrett's latest challenge, accusing Bondi's federalism of inviting fragmentation, echoed in the silent chamber, a direct assault on her vision of state sovereignty. The justices' stares bore into her, and Barrett's piercing gaze seemed to demand a reckoning. Bondi knew this was no mere question. It was a test of her constitutional mettle, and the wrong answer could tip the scales against her. Justice Barrett, Bondi began, her voice steady but charged, with purpose. Federalism isn't fragmentation. It's fidelity to the Constitution's structure. The framers designed a system where states retain powers not delegated, as Bond vs. United States affirms. Florida's regulations don't evade federal oversight. They exercise a state's right to govern local concerns, checked by judicial review, and constitutional limits. Her words were a deft parry, grounding her argument in precedent and principle. Barrett's pen hovered, her expression unyielding. Counsel, you invoke Bond, but that case involved individual rights, not state power. Your framework risks creating a race to the bottom, where states undercut federal standards for competitive advantage. How is that not a betrayal of cooperative federalism? The question was a scalpel, slicing at the heart of Bondi's thesis with a term that implied harmony over conflict. The gallery stirred, sensing Barrett's intent to corner her. Bondi's pulse quickened, but her focus was razor-sharp. Cooperative federalism, Justice Barrett, doesn't mean state subservience. It's a partnership, as Prince vs. United States clarified when it struck down federal mandates on state officials. Florida's regulations align with national goals but reflect local realities. The alternative, federal dominance, stifles innovation and erodes the 10th Amendment. Her response was bold, reframing Barrett's critique as a threat to constitutional balance. Justice Gorsuch's eyes flickered with interest, and Chief Justice Roberts leaned back, his fingers steepled. Barrett, however, was relentless. You're painting a rosy picture, counsel, but what about enforcement? If states adopt your approach, how does Congress ensure compliance with national priorities? Your logic seems to invite defiance. The question was a gauntlet, accusing Bondi of undermining federal authority outright. The chamber felt electric, every word a spark. Bondi met Barrett's challenge head-on. Justice Barrett, Congress retains ample tools, funding conditions, preemption within its enumerated powers, but the Constitution doesn't grant it veto power over state governance. National Federation of Independent Business versus Sebelius, limited coercive federal overreach. Florida's framework respects that boundary, fostering accountability, not defiance. Her voice carried conviction, each citation a brick in her defense. A murmur rippled through the gallery. Justice Thomas, ever stoic, nodded slightly, a rare sign of approval. Barrett's expression softened, but only for a moment. Counsel, your citations are impressive, but theory isn't practice. What's to stop states from abusing your framework, creating inconsistencies that harm citizens? You're asking the court to trust states implicitly. The question was less aggressive but no less probing, shifting the focus to real-world consequences. Bondi sensed a shift. Barrett's tone held a trace of curiosity, not just challenge. The duel was evolving, but the stakes remained sky-high. Justice Barrett, no system is perfect, but the Constitution trusts states to govern responsibly, subject to judicial oversight. Florida's approach is a model, not a mandate, as New York vs. United States supports. Citizens benefit when states tailor solutions, not when federal rules flatten diversity. Her words were a bridge, inviting the justices to see her vision. The courtroom hung on the exchange, sensing a turning point. Barrett scribbled a note, her face unreadable. As Bondi prepared for the next question, the air crackled with possibility. Could she not only withstand Barrett's onslaught, but reshape the court's view of federalism itself? The Supreme Court chamber pulsed with tension, every eye trained on Pam Bondi as she stood at the podium. Justice Amy Coney Barrett's latest question had shifted from outright challenge to a probing inquiry, hinting at a newfound respect. Yet, the stakes were unrelenting. Bondi's vision of federalism was on trial, and the justices' silence signaled they were weighing her every word. Barrett's pen rested on her notepad, her gaze steady but no longer cutting. The courtroom sensed a pivot, but Bondi knew one final misstep could undo her momentum. "Justice Barrett," Bondi began, her voice resonant with conviction. "Trust in states isn't blind, it's constitutional. The framers built checks into the system. Judicial review, the Supremacy Clause, and democratic accountability. Florida's healthcare regulations don't defy federal authority. They complement it, as South Dakota versus Dole permits when states innovate within constitutional bounds. Citizens gain when local solutions reflect their needs, not when one-size-fits-all mandates erase state identity." Her words were a clarion call, weaving precedent into a vision of balanced governance. Barrett leaned back, her expression softening into something approaching admiration. "Counsel, you've articulated a robust defense of state autonomy. But what's the limiting principle? Where does state power end if your framework prevails?" The question was no trap. It was an invitation, a signal that Barrett now saw Bondi as a peer in this constitutional chess match. The gallery leaned forward, sensing the duel had become a dialogue. Bondi seized the moment. "The limit, Justice Barrett, lies in the Constitution itself. States can't infringe on enumerated federal powers or violate individual rights, as cases like Arizona versus United States affirm. Florida's framework respects those boundaries, offering a model for federalism that's neither anarchic nor subservient, but cooperative in the truest sense." Her tone was measured but triumphant, her argument a tapestry of logic and precedent. The chamber was still, the weight of Bondi's words settling over the justices. Chief Justice Roberts nodded subtly, while Justice Gorsuch's eyes gleamed with approval. Barrett set down her pen, her voice softer now. "Thank you, counsel. You've given us much to consider." The words were simple, but their impact was seismic, a tacit acknowledgment of Bondi's brilliance. The gallery buzzed, and even Justice Kagan, often skeptical, offered a rare smile. As Bondi stepped back, the courtroom exhaled. The oral arguments concluded, but the exchange between Bondi and Barrett lingered, a masterclass in constitutional sparring. Weeks later, the court's decision rocked the legal world. A 6-3 ruling upheld Florida's regulations, affirming state sovereignty in a landmark federalism case. The majority opinion, penned by Roberts, incorporated Bondi's framework, dubbing it the Bondi Test, a standard for evaluating state laws under the 10th Amendment. It was a triumph not just for Florida, but for Bondi's vision of a constitution that empowered states without fracturing the nation. In the aftermath, Barrett penned a concurring opinion, praising Bondi's rigorous and principled advocacy as a model for the bar. The legal community buzzed with newfound respect for Bondi, once seen as a political figure but now hailed as a constitutional scholar. Barrett, too, earned praise for her incisive questioning, which had elevated the discourse and revealed Bondi's depth. Their clash, far from a humiliation, became a celebrated moment of intellectual humility and mutual respect. Bondi returned to Florida not as a former prosecutor, but as a legal titan whose arguments reshaped federalism. At a quiet dinner with colleagues, she reflected on the case, her eyes bright with pride. "It wasn't about winning," she said, "but about proving the Constitution still breathes." Across the country, law students pored over the Bondi Test, inspired by a courtroom duel that reminded them brilliance could emerge from the unlikeliest of stages, forging a legacy that would echo for generations.